Justice Alito?
Well, you just said that it's not discretionary. What if it were discretionary?
If Alabama, just to clarify, if Alabama had in effect created a discretionary innocent owner right, if you are an innocent owner, then the state may let you keep your car?
Yes.
I think that would likely not give rise to due process protections in much the same way that the remission procedure doesn't.
Could a state create an innocent owner defense but say that it can only be adjudicated at the final forfeiture hearing?
I'm not sure that it could, because I think at that point it's created a substantive right to the innocent owner defense, and the procedural protections that arise to protect that are questions at that point of federal law. I don't think that the state could curtail the right that way.
Well, some of my colleagues may not be interested in this question, but I am interested in this question. You have asked us to say that the Constitution requires this thing called a retention hearing. So I would just like to know, what is this thing that you are asking us to recognize? So how soon, what happens at it, how is it practicable for the police, and why is it necessary for the owner?
Sure. So first, we're not actually asking you to recognize that. We're asking you to decide the methodological question. And there may be ways in
Well, let me just interrupt you, because the last argument in your brief says that Alabama violated the petitioner's rights by failing to provide a retention hearing. But anyway, assume that that is part of the question. Go ahead.
So in terms of what a retention hearing looks like, I think the Legal Aid Society brief describes how these hearings have worked for 20 years in New York. In New York, it's a hearing that happens within, again, 10 business days, so a couple of weeks, at the request of the innocent owner. It is a hearing at which there are brief opening and closing arguments, and there can be evidence presented. There can be witnesses. At the end of that, the adjudicator will decide, is there probable validity for retaining the property? And second, what are the government's interests in retaining the property during the pendency of the forfeiture proceedings? Now, to address the government's concerns about evidence disappearing or evidence potentially being actually evidence in the underlying crime, those ex parte proceedings with the decision maker, with the judge, are an available tool in that situation to address the government's interests. So if the government comes in and says, this car might actually be evidence in the underlying drug crime, they'd probably be allowed to keep it in that situation, and that's something that could be addressed ex parte. The due process standard is flexible, including to protect the government's interests.
Well, let's just take what might be a sort of a typical case. So a car, similar to the facts in one of these cases, that a car is stopped by the police, they find a large quantity of meth in the car. The person driving the car is not the owner of the car. The person driving the car is the spouse or domestic partner of the owner. And then within a short period of time, there's this innocent owner defense. And the owner of the car, I suppose, testifies, I had no idea this was going on. And then what do you think the state what do you think it is reasonable to require the state to do in that situation?
At a minimum, I would expect the state to cross-examine the owner of the car. And by the way, the owner of the car would have provided that testimony under penalty of perjury. If they're later determined not to have been an innocent owner, then providing that testimony could subject them to additional prosecution just for that. So,
does that happen in New York City? Perjury prosecutions under those circumstances. Do you know of cases like that?
I don't know of cases like that, but I would also assume that people are not going to perjure themselves at the innocent owner hearing. But if the owner comes forward and testifies, this is my car and I had no idea about the wrongdoing, the government would have the chance to cross-examine them. The government would have a few weeks in which to have conducted whatever investigation they want to conduct. They would have the opportunity to make a case that way. They would also, if necessary, be able to go to the judge and say, here's evidence that we can only provide to you ex parte so as not to prejudice any later prosecution that they might bring. They might even be able to say to the judge, again, perhaps ex parte, we're in the middle of an investigation and we need a couple more weeks, and the judge would continue the hearing. There's flexibility flexibility built into this. But the point is that due process requires some sort of an initial determination.
All right. Thank you. Thank you.